All right, welcome to the video lecture on Chapter 10. Chapter 10 is all about the Fifth Amendment. So, the Fifth Amendment is really well known because we frequently hear people say that they're going to take the Fifth, and what that means is they are exercising their right to remain silent. But the Fifth Amendment is much broader than just your right to remain silent. So, first things first, there is a recognition that law enforcement do need the ability to speak with suspects to gather information and to try and obtain a confession. So they know who did it, so that they can effectively police, so that they can protect society as a whole. So there is a recognition that there is an important place for confessions in our criminal justice system. Now, let's start with the right against self-incrimination. The Fifth Amendment specifically says that no person shall be compelled in any criminal case to be a witness against himself. And that means you have the right to remain silent. Further, the Fifth Amendment says no person shall be deprived of life, liberty, or property without the due process of law. Okay? And the due process clause has been applied to states since the 1960s. So you do have the right not to incriminate yourself. Now, thinking about due process specifically, well, I guess really quick, self-incrimination, right to testify against yourself. There, it can be, you can still voluntarily choose to speak, and it doesn't include, it only protects you against kind of this testimonial compulsion. So speaking, so like DNA evidence from things, most jails and prisons routinely swap for DNA evidence and run through a database. That, while that does implicate you in, potentially implicate you in other crimes, that doesn't, the Fifth Amendment doesn't protect against that. So we're mostly focused here on talking, okay? Now, thinking about due process. Due process are the rules and procedures in place to make sure that we have fair, individuals receive fairness and that government cannot engage in arbitrary decisions. So the Fifth and 14th Amendments both guarantee your rights against due process. And there are two types of due process. There is procedural due process, which are literally just the procedures. Did you have a speedy trial? Did you have the right to a preliminary hearing? Was probable cause established? Those types of procedures. But there's also substantive due process. Substantive due process is much more focused on the subjective idea of fairness. Is the law fair, and is it being applied and executed in a fair and just way? So both of these components of due process exist and work together in conjunction with the Fifth and the 14th Amendments. So officer actions that are extreme can violate a suspect's right to due process, which is something that happened in Roshan v. California. Deputies entered his home. They saw him put 2 capsules in his mouth, and they took him to the hospital and had his stomach pumped. 2 morphine capsules were recovered and used as evidence against him. And the question was, did this conduct violate the Fifth Amendment privilege against self-incrimination and the due process clause of the 14th Amendment? And the Supreme Court said yes. The conduct here violated his right to due process. Due process can be vague, but it prohibits conduct that shocks the conscience. And they found that having a suspect's stomach pumped just because you saw them ingest something shocks the conscience. And so that was a violation of the Fifth Amendment. Now, Fifth Amendment applies to confessions. So confessions are routinely litigated out. There's a lot of jurisprudence out there, body of case law on confessions. Confessions are admissible. Not all confessions are admissible, which is a change in the law. Confessions have to be voluntary to be admissible. The exclusionary rule prohibits involuntary confessions or coerced confessions. One way that agencies will demonstrate a voluntary confession is by recording and videotaping. So that's a benefit of having recorded or videotaped interrogation proceedings. Now, if a confession is extracted after police violence, it cannot be used as evidence. This dates back to Brown versus Mississippi in 1936. Brown was treated horribly and then eventually confessed to a crime that he likely did not commit, just to stop the police violence. So that confession is unreliable, and then it's not acceptable, and the behavior may even shock the conscience. So for all of these reasons, violence cannot be used. Two factors are used to assess the voluntariness of a defendant's confession, suspect's confession. We look at the police conduct involved and the characteristics of the accused. And so what this means for police conduct, some police conduct is not acceptable. Threats of violence, shockingly inhumane conditions of confinement, interrogation after lengthy unnecessary delays in obtaining a statement between arrest and presentment before a neutral magistrate. So they can't just hold you and wait for you to kind of break and confess to something. Continued interrogation of someone who's injured and depressed in a hospital ICU, depriving a suspect of food, drink, or sleep. Those things violate the Fifth Amendment. Other tactics and strategies do not, including promises of leniency. Officers cannot guarantee leniency. Those decision to prosecute are up to the prosecutor. Encouraging a suspect to cooperate, even though it may not be in their best interest to do so. Promises of psychological treatment, again, law enforcement cannot guarantee that. Appealing to a suspect's religious beliefs, and trickery and deceit. All of these are okay. Again, we do have that, remember back to the very first slide, we do recognize the need for law enforcement to gather confessions. So there's not this outright limit. Now, when we think about the characteristics of the accused, the things that are considered are how old the defendant is, their education level, their intelligence level, whether they're mentally ill or not, and their physical condition. So we use kind of a totality of the circumstances and we evaluate this out. Younger juveniles, someone who is currently incapacitated, they maybe cannot give a voluntary confession in some circumstances. So if a confession has not been coerced, then it is presumed to have been voluntary. Okay, so if based on the police officer's conduct and the characteristics of the accused, it is not considered an inherently kind of coerced confession, then we presume that the confession that's given is voluntary. And we evaluate this under the totality of the circumstances. Was it truly voluntary? Did the individual understand their constitutional rights and were those protected? And was the good of the people balanced with the accused freedoms? So those are the types of circumstances that are evaluated during the totality of the circumstances. Now, we are finally going to talk about another incredibly important case that has really changed constitutional law. We're going to talk about Miranda versus Arizona. This is probably the most well-known case surrounding law enforcement. Most of the time, if we were in a classroom, I might ask who can say the Miranda warnings by heart, and usually almost everyone can. So the purpose of the Miranda warnings, and by the way, the Miranda warnings are that you have the right to remain silent. Anything you say can and will be used against you in a court of law. you have the right to an attorney. If you cannot afford one, one will be appointed for you. And the purpose of that warning is to let the suspect, the accused, know that they do have these rights and they can use them to protect themselves. Miranda was a poor 23-year-old male with a 9th grade education. He was arrested in his home for rape and taken to a police station where the witness identified him. Within 2 hours, he signed a written confession. He had never been informed that he had the right to an attorney. He had a right to have the attorney present while he was questioned, and that he did not have to self-incriminate himself. So he did not know this. The issue was whether or not police need to inform a suspect of custodial interrogation, of their constitutional rights about self-incrimination and the right to an attorney before they are questioned. So Miranda changed the analysis of Fifth Amendment protections against self-incrimination from totality of circumstances for voluntariness to whether or not those subjected have been advised of their rights. Now, custodial interrogation. This is when Miranda is required. Custody plus interrogation equals Miranda rights. Okay, it's not arrest plus interrogation, stop plus interrogation. No, custody plus interrogation. To be in custody, you have to be held in a place where you are not free to leave, where you are under the control and the authority of police officers. Now, if they just hold you and they don't ask you any questions, they don't have to Mirandize you. If they hold you, though, and they ask you questions, you have to have been read your Miranda rights, okay? So Miranda only applies to custodial interrogations. Now, Miranda warnings tells police officers that they have to tell people who are in their custody before their question, right to remain silent, anything you say can or will be used against you. You have the right to talk to a lawyer if you cannot afford one. Some officers prefer to use a soft Miranda warning, which sounds less harsh, and this is acceptable as long as all of the elements of the warning are given. Now, custodial interrogations. Warnings must be given to suspects who are questioned in police custody when the suspects are not free to leave. If an officer is unsure, they should Mirandize. Okay. Now, after Miranda is given, somebody can waive their Miranda rights. They can, and this is a purposeful and voluntary giving up of your known rights. So if you know and understand your constitutional rights, you can waive them. You can also revoke your waiver and refuse to continue speaking. So if after being read Miranda warnings, a suspect remains silent, just silent, they refuse to answer anything, that is not a waiver. Officers can continue to try and get the person to cooperate. To waive your rights, you must state it orally that you are waiving your rights or in writing. And part of that waiver is that you understand your rights and that you're choosing to voluntarily answer questions without an attorney being present. Miranda warnings are not required if you are not held by in police custody. So if you're being questioned by a private security officer, they're not required. Miranda warnings are also not required if there's an issue of public safety. So a suspect can ask them questions to address the issue of public safety without violating Miranda rights. This comes from New York v. Quarles. Quarles hid a gun in a busy grocery store, and officers, when they encountered him and they saw he had an empty holster, asked him, "Where's the gun?" And he directed them to that. That incriminated him, and he had not been Mirandized. But having a loaded gun hidden in a grocery store aisle is a public safety hazard. And so it's acceptable for officers to locate and remove the gun, remove the threat to public safety. And so that to not violate the suspect's Miranda rights. Now, under Miranda, fruit of the poisonous tree, violations of Miranda do not restrict the use of evidence gleaned from a statement made in absence of Miranda. So if your Fifth Amendment rights were violated, and you produce other evidence, under Fourth Amendment analysis, that fruit of that poisonous tree is likely not admissible. Under the Fifth Amendment, officers can use that evidence in another way. Now, entrapment can be used as defense here. We're not going to talk about entrapment more. That's more the realm of criminal law. Are other rights that are protected by the Fifth Amendment beyond self-incrimination and the due process rights are that in federal courts you have the right to a grand jury indictment. There's a prohibition against double jeopardy, and you have the right to receive just compensation if the government takes your private property. So those are the rest of the Fifth Amendment rights that are not as relevant to most criminal law and criminal procedure and constitutional law. Now, this doesn't matter if you are charged with a federal offense, but most criminal law is in state courts. Prohibition against double jeopardy. You cannot be tried for the same crime twice. There is an exception, though, for sovereigns. So a state government and the federal government can each charge you because they are each their own sovereign. So that does not violate double jeopardy to be prosecuted for the same action in both state and federal court. Fifth Amendment does apply to inmates that are being questioned about offenses that they're not currently serving time for. So if someone is being investigated for a different offense, they do still need to have their Fifth Amendment rights for that new offense. All right. There is a note. I'm not going to cover this in the lecture, but there is a note here about the Patriot Act. So, Fifth Amendment. It's very important that you know and understand Miranda. It's very important. That was what most of this video lecture was spent on. I also would think you do need to also understand the voluntariness standard for confessions as well. So, and then just kind of the basic definitions of due process and self-incrimination are also very important aspects to understand. So if you have any thoughts, questions, concerns about any of the content covered today, please feel free to reach out, and I'll look forward to working with you.